This is lordship, my lord.
Yes.
My lord, I beg to mention item number 13 and 14 of the supplementary list, my lord. These two matters may come up after vacation, my lord.
So due break,
Yes, my lord, yes,
item number 13 and 14,
my lord.
and council. Mr.
BK Das, my lord.
V. K.
And-
Das, hearing for the appellate, raised for and is granted 2 weeks time to complete his instruction.
My lord.
List of 2 weeks.
All
Well,
right.
item number 12, my lord, we have filed our affidavit in opposition yesterday, man. I am allowed to bring it to record, man.
Mr.
Be go.
Standing council, health and family welfare, submit that he has filed the affidavit in welfare yesterday.
Yes,
He shall tag the same with the record and re-notify the appeal on. When do you want,
they have called urgency, my lord.
you have got urgency,
My lord.
11th,
Affidavit.
11th or up to 14th, what do you want?
11, my lord.
11th, all right.
Obliged, man.
Lordship, with the consent of other party, I beg to mention item number 7. Lordship kindly fix the matter after vacation.
As prayed, list after Bihu break.
Yes.
Lordship, may I please, Lordship, I'm appearing to mention item number 16,
1-6,
item number 16.
yes, please.
Lordship, may kindly take this matter along with a similar matter, which is read application number 44/2023, which is
Council,
scheduled for next.
as prayed by Ms. Council, Ms. So-and-so, comma, rest is that file. Tag the file of writ appeal number,
44.
identical writ appeal number 44/23. Is that real, ration card matter,
Ration card matter.
and list both the appeals together with other identical appeals.
Yes, thank you.
Yes.
Item number 1 of daily list for motion.
May I, the lordship, this petition has been filed for non-compliance of order, lordship, page 20, lordship,
Page 20,
20, lordship, relevant pages 22, lordship. There is a direction, lordship, to the state respondent to lordship decide the representation as directed by this honorable court by order dated latest by 31.
8 weeks, okay.
Lordship.
The direction was given to who?
Lordship, the state
Deputy
has-
Commissioner. Heard issue notice to the
Lordship,
respond number 3.
2 and 3, lord.
Why 3? The direction is the respond number 2 only, 3 only?
Lordship, direction was lordship, we further direct the concerned authority of the state government to decide the representation of the lordship. So the both are lordship involved, lord. The principal secretary and lordship commissioner both.
I just read, learned counsel for the prisoners. Submitted. Read page 15. To whom is the direction given? Please read.
Page 22, lord. However, we further direct the
22.
22, lordship,
All
the
right.
below lordship.
What is this order then at page 14?
Page
What
14, this is lordship, page 14,
page, this order dated 20th
lordship.
January.
Lordship,
This is some other order.
other order, lordship, this order was not complied, thereafter, lordship, petitioner filed a.
The
contempt
fresh
petition.
read.
And in the contempt case, lordship,
This is contempt.
lordship, this order has been filed. Pass, lord. Page 22, lordship,
Already issue notice to respond number 1, 2. Only 2,
1 and 2, both are involved, lord.
1 and 2.
Lord. Obliged, lord.
Rule is made returnable. Steps for service be taken within 7 days. Rule is made returnable in 4 weeks.
Lord.
Item number 2.
May it please your lordship.
Yes, please.
My lord, on last occasion, if the lordship would kindly come to page number 101, or rather 102. During the course of argument, learned Advocate General of the state has made a statement that by of amendment made by notification dated so and so,
Okay.
the word commission has been substituted by the board in rule 6 and 10 of this so and so rule. Learned Advocate further submitted that apparently by not incorporating the.
All right, then you sought liberty to file a fresh writ petition.
Yes, now
by
we
making-
filed it.
necessary.
Now, my lord, this amendment does not, cure the defect which remains in our humble submission, my lord.
Okay, please.
The basic contention is, my lord, under proviso to Article 323. The governor is empowered, competent to, my lord, dispense with or take away the some post from the purview of commission, but it must be for some administrative exigency. It
Mhm.
cannot be a wholesome exercise, my lord.
Okay,
Now, if your lordship would kindly have Article 320, sub-article 3, my lord.
yes, please.
The Union Public Service Commission or the State Public Service Commission, as the case may be, shall be consulted. So on A to E,
Hmm.
then my lord will kindly come to the proviso. Provided that the president, as respects the All India services and also as respects other services and posts in connection with the affairs of the union, and the governor, as respects other services and posts in connection with the affairs of the state, may make regulations specifying the matter in which either generally or in a particular class of case or in any particular circumstances, it shall not be necessary for the public servant to be consulted. So if any regulation is made, it has to be made under this provision,
Mhm.
not under Article 309, my lord. Now, the state government has already made that regulation once, my lord. If your lordship will kindly have this book, ekhon ache নহয়? My lord will
Yes.
kindly come to page 91 of that book, my lord.
91,
Yes.
okay. Yes. Yes, please.
Kindly see, my lord, on top. In exercise of the powers conferred by provision of clause 3 of Article 320 of the Constitution of India,
Hmm.
and in supersession of previous orders on the subject, Governor of Assam is pleased to make the following regulation as respects services and posts in connection with the affairs of the state of Assam, specifying the matter in which it shall not be necessary for Assam public servant to be consulted.
Mhm.
So, my lord, if they want to make a regulation, they will have to make under this provision.
Mhm.
That's the settled position.
Right.
And moreover, my lord, the manner in which, my lord, the function of the commission has been taken over by the board. In my humble submission, my lord, this type of exercise cannot be undertaken. Lordship knows, my lord, in Keshavananda Bharati, Honorable Supreme Court said that Parliament cannot, in its ordinary legislative power, cannot even tinker with the constitutional provision. And by a subordinate legislation, where is the question, my lord? Therefore, my humble submission is, my lord, the regulation itself is ultra virus, my lord.
Mhm.
Therefore, the board cannot make any recruitment, my lord.
Mhm.
Yes, there are Supreme Court judgment where Supreme Court has said in administrative exigencies, some posts can be taken. Taken out from the
So
purview of the public service
let's
commission.
have a look at the regulation,
Yes, my lord.
whereby they have excluded
Yes,
the,
my lord, the regulation is at page number 77, my lord.
77. Yes.
In exercise of the power conferred by proviso to Article 309 of the Constitution of India,
Mhm.
Governor of Assam is hereby pleased to make the following regulation in respect of composition and staff of the Assam Engineering Service Recruitment Board, their tenure of office, the condition of service, along with the categories of posts for which Assam Engineering Service Recruitment Board shall conduct the recruitment process and make recommendation to the state government for appointment in those posts. So, my lord, in the comprehension of the Constituent Assembly, it is the Public Service Commission who has to make the recruitment.
Mhm.
Now, can governor in exercise of, my lord, power under proviso to Article 309, my lord, override that mandate?
Please satisfy us by some law,
Yes.
please.
Regarding, my
any-
lord?
Law on this aspect.
Yes, yes. First, my lord, my lord, I'll just refer to one paragraph, my lord.
Yes.
Para 19, page, para 24.
I'll just have your lordship's kind attention to para 20, my lord,
Of.
the writ petition.
Okay, paragraph. Yes.
That the petitioner respectfully begs to state that constitution of the Assam Engineering Service Recruitment Board itself is a nullity, inasmuch as board can commission with the meaning of Article 320 of the Constitution of India. It is needless to point out that in exercise of power under proviso to Article 309 of the Constitution of India, the government of Assam could not have framed the Assam so and so. The fundamental issue which arises for consideration in this writ petition is whether state government governor in exercise of the power conferred by.
The
provision-
ground you have taken, Mr. Chaudhary, that ground is taken.
Yes.
What is there to
My
support
lord,
this?
law, my lord, I have brought the decision on one point that by exercising power under 309, my lord,
Mhm.
a rule which is already there that cannot be overridden. That is there. But on the straightway on the point that since it is mandated that constitution, sorry, the commission will make the recruitment
Mhm.
and in such a circumstance, my lord,
Any judgment which supports the contention
Ah.
that encroachment cannot be made
yes,
into the domain of the commission
yes.
for making recruitment to state services by resorting to Article 309. That is your argument.
Yes, my lord.
So any judgment on that effect?
My lord, my lord, my humble submission is the Article 320 itself is already
The
clear.
language
I know, my
you,
lord, if your lordship wants authorities, I'll place.
we would like to
Today,
have.
today, to be honest,
On the other day,
huh,
Ms. Saikia was saying that there are authorities to the contrary.
yes.
So let us have a look at that, what he was citing.
Okay, lordships will have it on another. I'll come up with the case
Very,
clause. my
very
lord.
well. When?
Immediately after vacation law.
Okay, whenever.
No, my lord, recruitment has started. Let it be on 10th, my lord.
All right,
10th will be difficult, 11th.
11,
No, problem.
as usual. List on 11th April as jointly stated, jointly requested.
Item number 3 for admission.
deeply obliged.
Yes.
May I please your lordship. My lord, the impugn orders, my lord, page 87. Here, my lord, the facts of the case, my lord. An advertisement was issued, my lord, for the post of Gav Pradhan, my lord. And the read petitioner, my lord, who was, my lord, not eligible for submission of application,
Mhm.
he submitted application, my lord, along with the read appellant.
Mhm.
And after interview, my lord, read appellant was selected and read petition was not selected.
Hmm.
And under the rules, my lord, there is a statutory provision for appeal.
Yes.
Read petitioner, my lord, file an appeal before the tribunal, my lord. During pendency of the read appeal, my lord, he prepared a read petition saying that appellate tribunal has not taken any action.
Okay.
And on the basis of state read petition, the impugn order has been passed, my lord.
Just directing to decide the appeal.
Lordship.
So what is your problem with that?
Mm.
That is statutory remedy provided.
Next, my lord,
Yes.
I am agreed with the last, my lord.
What? Status quo.
No, my lord.
Then
Until such order, page 89, my lord.
89. What is this order on page 58?
The-
What is that order?
This was referred by the read petitioner in similar case that was passed by this all court.
Similar case means?
Similar, my lord, case referred by the read petitioner before the landed
It
single.
was relied upon
Lord.
judgment. Okay. Page
Impugn-
number 89.
Page 89, my lord.
All right. Yes.
Page 88, my lord.
Yes.
In response to the advertisement notice so and so, the read petitioner hearing had submitted an application for appointment as Gav Pradhan in respect of charge number so and so. However, in conclusion of selection process, the respondent number 6 was selected for
Mm.
appointment in Gav Pradhan.
Yes.
According to the petitioner, the respondent number 6 does not fulfill eligibility norms under the advertisement notice dated so and so. Notwithstanding the same, he has been selected for the appointment of as Gav Pradhan. Mr. So and so submit
That how he does not fulfill the immediate. Selection is state. Last time this is. By the argument of the individual that is not by hence. There is no observation. Yes, carry on. Yes,
lost,
yes. Until such time the appeal is disposed of, no order of appointment.
lost,
You are aggrieved by that?
lost.
Yes,
Because my lord, the read petitioner, my lord, he was not eligible. He did not pass, my lord, class 10.
okay.
Under advertisement, my lord, he should.
Who is
be
there?
class 10 pass.
Anyone for the respondents?
Government, my lord.
He'll state the order. No? I think this is, that's a election process. He has been elected or rather selected. Who is selection can be state? Built authority may reverse. That's a different thing. Till then his selection can't be called into question. Heard, issue notice to the respondents. Heard on prayer for interim relief. The petitioner is aggrieved by the interim, appellant is aggrieved by the interim direction given by order dated 1/3/2023 passed by Learned Single Judge, whereby, the appointment of the appellant within bracket respondent in the writ petition as Gaon Pradhan in respect of charge number 17, Bagbor Moja, Bagbor Revenue Circle, District Barpeta was stated. We find that though while disposing of the writ petition, you are not even heard.
No.
The appellant was not heard. Appears not to have been heard. It was on the first day.
On the first day, my lord.
Appears not to have been heard, and an adverse order staying his appointment as a Gaon Pradhan has been passed. In this background, passed. Furthermore, no reasons appear to be assigned for issuing a direction to stay the appointment of the appellant as the Gaon Pradhan. In view of the above, issue notice to the respondents. In the meantime, effect and operation of the order dated 1/3/2023, so far as it acts to restrain appointment order issued in favor of the respondent number 6 shall remain stayed.
Lord, one-
However, the direction given to the appellate authority to decide the appeal of the respondent writ petitioner shall remain in force.
Lord, on the basis of selection, my lord, others have been appointed. Because of this order, I have not been.
So we have stated that part.
So,
The consequence is you have to be appointed.
lordship, I am obliged.
You want a positive order of appointment. Why?
No,
You'll get double fees by that. We don't think so. Okay. Is there a prayer for interim relief? Mr. Counsel, is there a prayer for interim relief?
yes. Yes.
Yes, there is. Who is appearing for the state authorities? Madam is appearing, Madam Secretary. Notice be issued to the respondent number 1 only. Steps be taken in 3 days. Rule is made returnable. For 1 you are there. Writ petitioner. Respondent number 1 is the writ petitioner.
He is a private.
Government officials, you may mark attendance of the concerned council. Rule is made returnable in 6 weeks. Yes.
Item number 6 of supplementary list for admission.
Yes.
May I please, the Lord. I'm appearing for respondent number 1, my lord.
Mhm.
Pursuant to last order on 17/2 by your lordship, the one committee was appointed and within 90 days, they are going to hold the election. Process initiated.
One
One man committee.
has been appointed.
Yes, my lord.
And what has happened thereafter?
Thereafter, my lord, process is going on to hold the election under the act
Miss,
within a period of 90
Mr. You are,
JMA Chaudhary. I am for the respondent number 1.
okay, Mr. So and so. JMA Chaudhary,
Yes, my lord.
appearing for the respondent submits that process of election in terms of the directions given by this court on 17/2/2023 is underway.
Yes, ma'am.
List the latest status report be placed for the court's perusal on the next date. List after 6 weeks.
Lords.
Item number 8.
None present for the appellant, you'd like to mention.
My lord, in this case, I am led by Mr. UK Nair, senior advocate, my lord. He is coming, my lord.
Pass over.
Item number 9.
My lord, we intend to file an additional affidavit bringing on record the particular representation. We may be given 1 week's time. my lord.
General Counsel, Mr. Chaudhary submits that he proposes to file an additional affidavit on behalf of the appellant
Appellant, my lord.
to bring on record certain additional facts. If place for is granted,
1 week's time.
1 week's time to do the needful. List thereafter.
Item number 10,
Yes.
On 13/2/2023, my lord, necessary instruction was called for, my lord. My lord,
Das.
Hello.
Yes,
Can I take to impugn order page 85, my lord?
85.
85 to 90.
Yes. What is the appeal about?
My lord, only the repetition was dismissed that certificate issued by the deputy commissioner, Nagaon, was not as per provision of the under rule 2A, my lord.
Yes.
And injury report also not included in this.
Injury report.
My
Oh,
lord, annexure 6 page.
just hold on. hold on.
Annexure
Page
6
89, para 10, 11 will clear everything, my lord.
Yes. Probably Rupam, we have decided few appeals. Let's get that judgment. 99 rules. Report submitted by the CO on 1/2/17. Is there no limitation to issuance of such reports? Anyone can issue reports after 20 years, 25 years. What is the sanctity of such reports?
My lord,
What is the contemporaneous record? We are asking him. You can take your seat. Mr. Counsel, Mr. Islam,
My lord.
what is the contemporaneous record to satisfy the court regarding veracity of this report?
My lord, in the initial, my lord, in the repetition, my lord, injury report was not enclosed. My lord. They are subsequently in the repeal, my lord. Kindly see page 20 to 24, my lord. Annexure 6 and 6, 7 and 8, my lord.
Read para 11, please.
Page 20 to 20.
Para 11, what we are trying to convey has been taken note of by learned single judge. Para 11 of the order, please.
page 89.
Page 89, para 11.
My lord. Here, my lord, para 11, my lord. A PSL of
Yes.
certificate issued by the deputy commissioner office, which is annexed to the repetition, clearly shows that it is not been made in terms of schedule appended to the 1990 rules, and as the certificate issued annexure 3 of the repetition cannot be acted upon, my lord. My lord, then thereafter, my lord, in the writ appeal, I have enclosed to the injury report annexure 6, my lord.
Writ appeal.
My lord.
So if you were not having some document,
That certificate,
Mr. Islam,
my lord.
then this is a new document you want to bring on record. Go file a review. That is the remedy. Why should we have a look at the document in appeal, which was not a part of your writ petition?
Then, my lord, kindly remand back to the single bench.
You withdraw it,
I will file the review.
the counsel, Mr. Islam, waives liberty to withdraw the instant. Writ appeal seeking leave that the petitioner may be permitted to file a review petition before the single bench, annexing therewith, comma, a medical certificate of the petitioner's father, which the appellant's father, which the appellant could lay hands on after the writ petition was decided. Accordingly, in view of the statement so made, comma, the instant writ appeal is disposed of as withdrawn with the liberty prayed for.
Deeply.
item number 11,
Yes.
May it please, your lordship.
Yes, please.
The state respondent was directed to produce the instructions, my lord.
Yes, please. Madam, what are you showing? What have you presented?
Lordship, last occasion, Lordship directed us to obtain instruction on the modalities of compliance of clause 15 of the OM dated 1/6 of 2015.
Hmm. Okay. Okay.
My lord, with regard to the OM, my lord, that I have last time has given, my lord, it is in the file, my lord.
Mhm.
Regarding, my lord, clause 15, my lord,
Yes.
it says, my lord, if sufficient vacancies are not available in a particular office
Hmm.
to accommodate the petitioner in the waiting list for compassionate appointment,
Mm.
it is open to the administrative department to take up the matter with other departments, office of the government to provide an early appointment on compassionate ground, my lord.
Yes.
With that regard, my lord, they were
Yes.
asked to produce the instructions, my lord.
Point number
Point number 15, my lord,
15.
15.
Yes, this was the direction, madam.
Lordship.
What about that? We had given you particular direction to receive instructions for the modalities of clause 15,
Yes, sir.
that whether the case can be considered in other departments
Lordship.
where vacancies are pending, available.
Yes, Lord. Yes, Lordship, there clause 14 provides for 14 of the
15,
OM.
15,
It will be
15, madam.
incorporated after clause 14 in the OM for taking of those cases for appointment under completion ground. While vacancies are not available in particular office to accommodate the person to take up the matter with the gov departments or offices where vacancies are available. At a
So
particular.
these
time.
modalities are there. Modalities, we meant that whether you can consider the case
Yes,
of the writ appellant under this clause.
yes, Lordship.
What is your stand?
You can-
Current Government Council shall take instructions as to whether the case of the appellant, writ appellant can be considered for compassionate appointment can be considered in light of principle number 15 of the office memorandum dated
1st of June, 2013.
1st June 2013,
50.
clause 15 condition. List of 4 weeks.
না, এখানে
Mr. Saikia, and single is, my sister is telling me that there is a new policy of the government that no compassionate appointments henceforth. Is there
No,
something?
no, we have changed it. The compensation, there is no compensation, but the family will get the same
Salary till
till the retirement, and
Retirement.
after thereafter pension also. We have converted, it's much better now. Earlier, there was a cap of 5% of the total
Mhm.
vacancies in a year. Very few get it. Now everybody
Well,
gets,
those cases which became ripe earlier,
yes.
they would be covered under the standing.
That is an issue that there's a appeal also which will come before this honorable court
Okay,
on
okay,
this
okay.
point.
Can we have that
Policy?
latest policy, please?
Tomorrow, next
You
day,
ask your associates, they will
Yes,
send
Lordship.
it out, please.
we have the changes policy about 2-3 years ago. It is much more beneficial now.
Naturally.
No.
There's no scope of litigation then.
No litigation and there is no scope of heart burning also.
That's true, that's true. Right.
Matter number 15.
Family will not suffer a single day.
Naturally. And yes, compassionate appointment being an exception to the normal mode of
Yes,
recruitment,
Exactly, Lordship. The family
unnecessarily,
in great harness once the main bread earner goes away, Lordship, untimely.
that's right. Yes,
Matter number 15.
yes.
Please, your Lordship, my lord, yesterday, your Lordship desired to know from the government, my lord, what is the number of vacancies and the number vacancies, your matter, what the number of.
This is matter
candidates
we took
applied.
up yesterday.
Yes, my.
Yeah,
And in fact, my lord, we have downloaded from the website the entire list of candidates. And that sheet is also there. And my lord, we have prepared a chart out of that, my lord.
let's see.
Which will show the, my lord, clear picture of the number of posts advertised and the, my lord, candidates applied. If I may submit that, my lord.
Please.
So far as graduate teachers are concerned, total number of posts advertised are 7,776,
Mhm.
7,776.
Yes,
Out of that, my lord, actual number of individual candidates is 2,214. And my lord, these candidates also, my lord, many of them have applied in, my lord, more than one post. For
Okay.
instance, one Hindi teacher, He applied for Hindi teacher, also graduate teacher.
Hmm,
So actual number of, my lord, the candidates will be much less.
hmm.
So out of 7,766, it will be around 2,000.
2214 as per
My
you.
lord. And so far as my lord, the postgraduate teachers are concerned, 1503 posts have been advertised.
Hmm,
And my lord, I have given that chart, my lord, along
Yes.
with the names of the
Yes.
persons. If your lordship, my lord, in the graduate list, your lordship finds the same candidate, for instance, my lord, serial number 1,
Hmm.
he applies for 2 posts. Serial number 2, applies for 2 posts. That's why,
Yes.
my lord, the number of candidates will be much less.
Okay, okay.
Serial number 2 is 2 posts. That is. Oh, and government, my lord, he applied for 3 posts.
Hmm,
So there are not, no, my lord, enough number of candidates. And all these candidates have had the opportunity to, my lord, compete in the 2019 advertisement, and they did
But
not.
what
succeed.
yesterday Mr. Mazumdar said, that your clients also had the opportunity.
No, my lord, that is a wrong statement. I'll show, my lord. If your lordship kindly takes up my writ petition,
Yes,
I have given the complete list of names of the petitioners and my lord, and when they have passed. None of them, my lord, had the, my lord, B.Ed degree at the relevant point of time when the 2019 advertisement was made.
not 19, 21 you were saying. You were saying about 21 TET exam.
21.
Was there a TET exam in 21?
Yes. 21, my lord, 20 and 21 TET was held, my lord.
Then,
At that point of time, we did not, my lord, that in the meantime, my lord, the last days have gone. Your lordship will see, my lord, if your lordship kindly takes up by that list of the, my lord, petitioners,
please do.
I have annexed at page 121, it starts. My lord, all
Just-
the candidates,
yes.
101 candidates names we have given, page 121 is the running page.
Yes,
Your lordship will find, my lord.
Yes.
Kasturi Das, the petitioner number 1,
the B.Ed,
the B.Ed degree in
B.Ed has been acquired in 21,
21, my lord. She could
21,
not have been
22.
22,
Maybe
my lord.
the TET exam might have been held earlier.
Yes.
Many a times degrees are received later. All these candidates acquired B.Ed probably after your exam was held.
Yes, my lord.
That does not make any difference, Lord. That is not relevant. The relevant is that whether to appear in the TET, whether he is graduate or not.
Hmm.
B.Ed will lage na? B.Ed
Only graduation.
No, no, I'm sorry, Lord.
B.Ed would be necessary.
B.Ed will be
B.Ed
necessary.
is mandatory.
Only thing is that, Lordship, we are going to have a paradigm shift in this whole policy.
Mhm.
What they are saying that every year we have to conduct that,
Hmm.
that is not required so far as the secondary education is concerned. It is mandatory for the elementary.
Yeah.
We have decided, Lordship, now we are going to get away with this TET for the secondary.
Mhm.
So this, whatever we have conducted in 2000 and 2021, Lordship,
Mhm.
that is the last. So
Okay.
far as the secondary education. is
Secondary
concerned.
education is concerned. Okay.
Now, the persons who are there,
Mr.
they are
Saikia,
around 100,
what is bothering us is
Lordship.
that you have got 7,000 vacancies.
Yes.
You don't even have one
Because-
third of the candidates.
Yes, there's a conscious decision regarding this. We know that the total number of vacancies and the total number of TET qualified persons, the vacancies are more than the TET qualified.
3 times,
Not 3 times, Lordship,
3
little
times.
bit more.
3 times.
No,
This is
no,
chart.
it is not like that, Lordship.
Please have a look
I
at the
have a
chart.
figure.
He has also got the figures. Please
This figure
verify.
is not telling with us.
Maybe all right. We can
So
ignore
let us,
that.
let them also file an affidavit, we'll also file an affidavit on the.
Assuming that your figure is correct, still 50%.
I am not sure. No.
Yes. Secondary school, 776 posts and total number of applied candidates, 3262. That
In
figure can't be dis-
Secondary, Lordship, total vacancy is 1499.
That is secondary school.
In the higher secondary postgraduate, total
Yes.
1499. And the
1503.
That is the
It is-
advertisement. That is the number.
All right, 1503 or what is 1492, whatever.
1499.
Yes.
That is 1500. And the
Yes,
application we have received is 1559.
yes.
So it is more. Then in case of the high school for graduate teachers,
Yes,
the total vacant post is 7,785.
yes.
And we have received actual applications at 3,447.
So that is 50%.
So that
only.
is 50%. The
But-
other, it is more than 100%.
If you can make a statement that for secondary schools,
Yes,
you are doing away with the requirement of
yes,
TET,
Lordship.
then they will get the chance.
They will get.
For
a
the
chance.
remaining
That is what-
posts.
That is precisely my submission before the learned single judge.
Let us participate in this, my lord, then, if you are doing away with it.
Then Mr. Saikia, if you are doing away with TET, then why hold this examination?
Because there's huge vacancies in the schools.
Then all right, take the decision
No,
immediately.
our selection is over. In 3 days, 4 days time, the select list will be out.
No, my lord, that is.
Then
that-
again, I have a written instruction on that.
We'll-
I have, in 4 days, further time.
We'll,
is required. I
we'll
will-
take his version of that.
Lord.
If the selection is over, what to do, sir?
My lord, if your lordship may kindly have a look at this. They are still, my lord, going with the classification of the candidates as per.
Let us get his
district-wise.
affidavit.
May I read it, Lordship?
Yes,
What is
please.
the instruction?
Yes,
All the applications which were filed before the last date of filing applications have already been processed through physical verification of documents that was conducted from 6/3/2023 to
yes.
17/3/2023 by calling all candidates
Hmm.
of all over the state in the office of the Director of Secondary Education, Assam at Guwahati.
Yes,
The candidates whose applications have been found to be proper were thereafter given the options to select their district.
that
of
is counseling. That is counseling for posting. This is what you're
Yes.
given it. That's a counseling for posting.
True.
So selections are over, then only counseling will begin.
Yes,
No, my lord, my lord, that is.
our
already-
academic session has started, so we do not want any student to suffer. It is basically a
My lord-
student-centric policy.
There is a division-based decision of the honorable court.
Right.
In that division-based decision, my lord, it has been held, my lord.
Yes, please.
If your lordship kindly comes to page 59, it starts. The
59,
relevant is at page 64.
59.
Relevant, my lord, paragraph 15 at page 64.
64.
My lord.
Yes.
Paragraph 15. In that circumstances, even though we arrive at a conclusion that the appellants and the similarly placed persons should be provided an opportunity to participate in the selection process, if in order to enable them to participate in the advertisement A and B dated 11/3/2018 are quashed, it would affect the interest of the candidates who are otherwise held qualified in all respect, including holding of qualified test, date, etc. My lord.
Ms. Chaudhary,
My lord, thereafter
this
your lordship.
situation here is different.
My lord.
Now the government is taking a decision. No more TET examinations for secondary, higher secondary.
That's the, my lord, reason enough to give us the opportunity to participate.
No, but when, if you are allowed to participate, what happens to the process which has taken place already?
My lord,
What will happen then?
My lord, that process is.
You,
my
you
lord,
see,
flawed.
the writing is on the wall that 5,000 seats will remain vacant. Wait for a while, let the policy, let us take this statement on writing, then your clients will have a chance. There are only 100, not more.
There, my lord, the numbers here, your lordship has already seen, my lord, 2,214.
We understand. So 5,000 posts will be vacant
My lord.
as per you. They gave a statement. Let us have it on record that no more TET for this category. And then we'll request the government to initiate that process for the non-TET qualified candidates at the earliest.
No, your lordship will only, my lord, the one aspect your lordship will kindly see, my lord.
Yes,
These persons who will now be selected and appointed, my lord,
yes.
they had the opportunity earlier. They did not, my lord, perhaps
Then
qualify.
at any particular point of time, they have qualified TET. It's a fact.
Yes, my lord.
So should they be allowed to
They-
remain?
They qualified that earlier and thereafter they appeared in 2019 selection, my lord.
All right. So they were not selected.
They were not selected.
It doesn't matter.
We
That
want
is
to
not the
compete with
end
them.
of the things. The
Purpose is to get better candidates, my
So
lord.
that is not the end of the things. What is the guarantee that your clients will succeed in TET?
True, my lord.
Then,
That
all right. You file the affidavit, Mr. Saikia.
Yes, Lord. It is on record, Lord.
Advocate General, Mr. Saikia submits that the state has taken a policy decision not to do away with the requirement of TET qualification in selection on the post of graduate teachers in provincialized secondary schools. He
Graduation as well as post-graduation.
graduation as well as post-graduation. He so he will place on record
Lordship.
an affidavit to fortify this assertion
Lordship.
within next 7 days.
Lordship.
List on. When do you want?
Let it be on 11th.
11th.
Very good.
We'll file the affidavit.
Yes.
Highly obliged.
Item number 17.
Yes.
I believe your lordship. This is regarding compassionate appointment, my lordship.
Yes.
My application has not been considered, my lordship.
Why? What the single judge says?
Firstly, my mother applied, my lordship,
Delay.
and thereafter,
What happened to your mother's application?
my lord, it was, there is no response, my lord. Kindly peruse page 27, my lordship.
Read para 6. Family of the petitioner survived for 22 years. So that need for tiding over penury is no longer there. It's a settled principle of law.
My lord,
Yes,
we are, when our father died.
it's
my lord,
not a right, sir. Compassionate appointment is an emergency measure to provide the family a breathing space when the sole breadwinner goes. But you have survived for 22 years and the case of one of the dependents has been considered. So where is the question? This is
No,
not in
no,
succession
my-
that you get it.
Our mother's application was not considered, my lord.
Let us see, then she should have come to the court in a writ jurisdiction. Is this right an inherited right?
No, my
Or rather, there is no right as such.
Hmm.
It's only a consideration, nothing beyond that. Dismissed.
Matter number 4 of daily list for order.
My lord, there is delay of 4 days, my lord.
4 days,
My lord, we may be permitted dasti also, my lord.
issue notice. The connected writ appeal is delayed by 4 days. Issue and IA number so and so has been filed under section 5 of the Limitation Act, seeking condonation of the delay. Issue notice of the IA to the respondent. Steps be taken within 3 days. Dasti service is permitted. Rule is made returnable on
Let it be on immediately after Bihu vacation. On 19, 20, 21, any date, my lord.
25th,
My lord,
25th April.
deep level.
Matter number 5.
Yeah, please.
Yes.
There is this application is for delay of only 484 days, your lordship.
How many days?
484 days, your lordship.
484.
Okay.
How have you explained it? Let us see.
Actually, Lordship, after the impugn order, your lordship, as per the advice of the council, applicant, your lordship, there is a review was pending, your lordship.
The review was pending.
Yeah, lordship.
When was the review decided?
Review is 9/1 to 13, your lordship, 23, your lordship.
9/1/23.
Yeah.
What do you say?
There is a private respondent also.
Private respondent. Issue notice of the IA number so and so to the respondents, Mr.
Five and six.
You are appearing for
I am applying for the secondary education.
for the State Education Department, Mr. Mozumdar
1, 2, 3. Madam.
appears for the respondents numbers 1, 2,
3 and 4.
3 and 4. Notice process be issued to the respondents numbers 5 and 6. Requisites be filed in 7 days.
Dasti may be allowed.
Dasti service is permitted. Rule is made returnable in 4 weeks.
Matter number 18 of supplementary list.
Yeah, please, your lordship. Lordship, this matter pertains to non-issuance of ration card.
On issuance of
Ration card, lordship.
ration card.
Yes,
Okay.
lordship. Pleading is completed, so this matter may be fixed for hearing.
Hearing, all right.
After
The readings have been completed. As played by counsel for the appellant, list for hearing in the month of after summer vacation. All right.
Lordship, I may just clarify, Lordship, I have not filed my affidavit because the relief thought is primarily against the.
Mr. R.K.D. Chaudhary, Deputy SG, Mr. Chaudhary submits that as no relief has been sought against the Union of India, there is no requirement to file an affidavit on its behalf. All right. Other respondents have already filed their affidavits. List for hearing after summer vacation.
Matter number 19.
May I please, your lordship?
Yes.
The authorities, my lord, are seeking a further 3 weeks' time, my lord, to demarcate the land of the writ petitioner.
Mm.
But here the matter is, my lord, in a narrow campus, my lord, way back in the year 2005, when the national games were held in Guwahati. My lord, certain lands were dug out, my lord, for, my lord, holding the event of rowing. Now, my lord, the petitioner's land, my lord, writ petitioner land, which was in the vicinity of those land, my lord, it was also dug out, my lord, admittedly, it was made totally inhabitable. Planet Single Judge, my lord, had directed the deputy commissioner as well as the revenue department,
Mm.
my lord, to either compensate the writ petitioner with some quantum of money, or, my lord, in the alternative, to provide some alternative land.
Land.
Now, my lord, that being the position, my lord, in between during the course of the proceedings of this hearing, my lord, of the instant writ appeal, that a development has taken place, my lord, that the authorities have now swung into action, and they are taking an exercise, my lord, to restore the land of the petitioner. My lord, that will suffice, my lord, his whole grievances will suffice. Now,
Alright.
my lord, the problem is that, my lord,
Restore in what manner?
my lord,
What was the land used for?
it was used, my lord, for the purpose of holding the events of rowing.
Rowing.
Rowing, it was completely dug out.
Okay, it was dug up.
It was dug up, and, my lord, the petitioner's land was neither acquisition nor requisition for the purpose of holding the games.
So what about the years for which he has suffered for this
That is
act
true.
of your authorities?
My lord, that is true, but
Why not additional compensation on that ground?
my lord, the authorities had filed an affidavit before the honorable single judge stating, my lord, that in clear terms that his land was not required, and it was not acquisition for the purpose. My lord, the authorities who had conducted the national games, they had, my lord, on the.
Who are those authorities?
My lord,
They are your constituents.
No, my lord, they are the National Games Secretariat as well as, my lord, the Department
Who
of.
provided the civil equipments, mechanical equipments, engineering equipments? They wouldn't have brought them from Delhi. We are sure.
Yes, my lord, we are the authorities, my lord, revenue authorities, we are concerned with, my lord, protecting.
All
the
right.
status of the land.
Do you mention it on affidavit that you will restore the land?
No, my lord, it has been called out, my lord, from some orders passed by this honorable court, my lord. And this is how, my lord, the matter is proceeding, my lord.
No, but the report which you have submitted is that survey could not be conducted,
Yes, sir.
completed. Survey for what purpose?
The survey, my lord, for demarcating the land, because it is totally, my lord, waterlogged. It's totally waterlogged. Lordship will kindly consider, my lord, authorities are there, my lord, they are exercising, my lord. Some time will require, my lord, because of, my lord, harsh weather conditions, my lord. These days, my lord, there is, my lord, incessant rains, my lord.
What
And
is the area?
My lord, the area is located, my lord, near the Deepor Bill, my lord.
Deepor Bill.
Deepor Bill.
So what kind of inclement weather we are facing right now? Hardly a spell of rain for an hour or two.
Yes.
What is the difficulty?
No, my lord, the land has been totally, my lord, become, my lord, inaccessible. They have also engaged drones at some point of time.
Okay.
It is not that.
All right, Ms. Council.
I
if
am
the-
for the respondent number one, owner of the land, my lord. I am a handicapped person, my lord.
We understand.
Running behind
We
the
understand.
authorities more than 20 years, my lord. And
Last opportunity of 4 weeks. Otherwise, we'll line up your authorities in the court on day-to-day basis. Convey it to them. All right. And council, your Mr.
My lord, R. Pujari.
R. Pujari, standing counsel for so and so submits that the authorities are now undertaking an exercise for restoring the land of the writ petitioner.
My lord.
Then counsel Mr. So and so appearing for the writ petitioner submits that his client is a handicapped man and it is now almost, he is a differently able man. And now he has been deprived of his land for almost 20 years
my lord.
on account of the high-handed action of the respondent authorities. Considering the facts and circumstances noted above, gravity of the facts and circumstances noted above, we hereby direct that the complete process of restoring the land of the respondent providing him a suitable alternative piece of land shall be completed within next 4 weeks. If the process as directed above is not completed by the next date of listing, the respondent officers holding the respective posts of respondents shall remain present in the court. List on 11th May.
11.
Yes.
Lordship may precisely direct the deputy commissioner because he is the authority under whom the.
All authorities,
My lord, my lord.
you convey the order to, the copy of this order shall be conveyed to respondent authorities, to the appellant authorities by mail. We have to mention appellant authorities, not the respondents.
And so.
Obliged.
Okay.
Matter number 20.
May I please, your lordship? Lordship, we have filed our affidavit, rejoinder affidavit on 21/9/2022. in
Yes.
This matter. Lordship, this matter also can be fixed for hearing.
Hearing,
Yes, lordship.
and counsel for the appellant submits that as pleadings are complete, comma, the matter may be listed for hearing, ordered accordingly, lists for hearing in the month of August.
Deeply obliged.
Matter number 21.
Yes.
May it please your lordship? Lordship, as per the last office note, the service in respect of respondent number 3 is complete, lordship.
Lordship, I am applying for.
All right. So all respondents are represented.
Lordship.
The respondents' service has been effected on the respondents' list for admission after 2 weeks. None? Okay. Only 7 matter. I told them. Okay. Yes.
Lordship, the matter may kindly be passed over for the day, lordship.
Then I have a pair lordship after 25th lordship. I am out of station up to 25th lordship.
After 25th, you are out of station.
Okay.
So we listed before that,
Before
list
that-
on 19th.
No, lordship, I am from 11 to 25th, I am out of station. lordship. Then
What
lordship,
is-
before that, I know, otherwise.
Like list on 26th as per
Lordship,
26th April.
lordship, obliged.
Much obliged.